Good evening and welcome to tonight's meeting of the Sparta Township Planning Board. Thank you to those who are joining us here and online. For the record, this meeting is being held on March 4th, 2026 at 7 p.m. in the Sparta Township Municipal Building, located at 65 Main Street, Sparta, New Jersey, and the live stream can be viewed on YouTube at www.youtube.com/@SpartaTWP. Please note that adequate public notice of this meeting was given in accordance with the Open Public Meetings Act. No new business will be conducted after 9:30 p.m., and the meeting will end promptly at 10. Let us begin with a salute to our flag. I pledge
Allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Raisha, would you please call the roll?
Birgit Bogler.
Here.
Brian Zimmerman.
Here.
Ron Day.
Here.
Ernie Ragsdale.
Here.
Vice Chairwoman Jeanette Burke.
Here.
Chairwoman Celeste Luciano.
Here.
Deputy Mayor Mike Sylvester.
Here.
Christine Quinn.
Here.
Christine Dunbar.
Here.
Joan Furman.
Here.
Thank you. Moving on to our executive session.
Yes, if we can hold off on the executive session until the end of the meeting. If any issues come up on the detention center that I feel that we should go into executive session, we could do at that time, and we can talk about Diamond Chip at that time, if that's okay with you.
If that's your advice?
That's my advice.
Is that a consensus of the board? Should we do that as by a motion?
That'd be fine.
So may I have a motion and a second to move the executive session to the end of the meeting?
So move. I'll second.
Roll call, please.
Christine Quinn.
Yes.
Deputy Mayor Mike Sylvester.
Yes.
Ron Day.
Yes.
Christine Dunbar.
Yes.
Joan Furman.
Yes.
Ernie Ragsdale.
Yes.
Brian Zimmerman.
Yes.
Birgit Bogler.
Yes.
Vice Chairwoman Jeanette Burke.
Yes.
Chairwoman Celeste Luciano.
Yes.
Good, thank you.
Okay. Moving forward to the next section, the approval of minutes. We have minutes for February 4th, 2026. Eligible to vote are Deputy Mayor Michael Sylvester, Jeanette Burke, Ron Day, Christine Dunbar, Joan Furman, Celeste Luciano, Ernie Ragstad, and Birgit Bogler. Any comments or questions from the dais regarding these minutes?
I have one change, please, on page 1, where it's approval of minutes, fourth paragraph down. I'd like that to be reworded. Ms. Furman stated she added limited clarifying items, but did not change other previous language.
I'm sorry, which paragraph was that, Joe?
Under approval of minutes, fourth paragraph beginning with my name.
1, 2, 3, 4, okay. And I'm sorry, could you please repeat that?
Ms. Furman
Clarifying
stated
items?
she added limited clarifying items, but did not change other previous language. In other words, the previous paragraph, I wasn't responsible for drafting the feelings and thoughts that were a concern. That wasn't mine.
Any other comments or questions from the board? Hearing none, I would like a motion and a second to approve as amended.
I'll make a motion.
I'll second.
Roll call, please.
Christine Quinn.
I can't vote.
I'm sorry.
Sorry, I can't.
I'm sorry. Deputy Mayor Mike Sylvester.
Yes.
Jeanette Burke.
Yes.
Ron Day.
Yes.
Christine Dunbar.
Yes.
Joan Furman.
Yes.
Celeste Luciano.
Yes.
Ernie Ragsdale.
Yes.
Birgit Bogler.
Yes. Okay, moving forward to minutes for February 18th, 2026. Opening it up to the board for questions and comments on these.
I believe you already made the change that I emailed about
another
Yes.
member being changed to my name.
Correct.
Great, thank you.
And I have one other, again concerning my name, under updates on the last page. That can be changed to Joan Furman revisited a topic from prior board meetings and requested a legal opinion as to whether planning board alternates can vote on applications when a seat is vacant and no regular member is assigned to the seat.
Okay, so that was Joan Furman brought up whether planning board alternates can vote on, can you please repeat that?
Joan Furman revisited a topic from prior board meetings and requested a legal opinion as to when a seat is vacant and no regular member is assigned to, oh, I'm sorry, I skipped a part, as to whether planning board alternates can vote on applications when a seat is vacant and no regular member is assigned to that seat. Because the way it reads now is when a regular member is absent, and that's incorrect.
Any other comments or questions on these minutes? Hearing none. May I have a motion and a second to approve the minutes from February 18th as amended?
I'll make a motion.
I'll second.
Yeah, we'll, excuse me, roll call, please.
Deputy Mayor Mike Sylvester. Jeanette Burke.
Yes.
Ron Day.
Yes.
Christine Dunbar.
Yes.
Joan Furman.
Yes.
Celeste Luciano.
Yes.
Ernie Ragstat.
Yes.
Brian Zimmerman.
Yes.
Christine Quinn.
Yes.
Birgit Bogler.
Yes.
Thank you.
May I do a follow-up to that, please? Since we have before us coming up where we do have votes, and they are land use votes, they are the ordinances that we're going to be looking at tonight.
Sherman, can you talk into the mic?
I'm sorry, can you, these are very,
Are we having problems with live stream too? Because,
It's streaming. Let me,
Testing, testing, testing.
Yeah. Is it on mute? Maybe you could
the
flex
lights are coming on, so
They're not, yeah, the lights come on, but
Testing, testing. Testing, testing. Testing, testing.
it's picking it up and bringing it online. It's not picking it up and transmitting it in the room.
so it may just be the speakers in here that are off.
Oh, good call.
is there a switch for them? Oh, testing? No.
Hello?
Testing, testing, no?
Apologies.
Testing, testing.
I think it's just the room.
Dave, is yours on? No.
Let me see.
Testing, testing.
All right, so we apologize to everyone in the room. We're going to try to see what we can do about fixing the situation. We will attempt to be as loud as possible. I'm usually pretty loud, so if people can't hear me, let me know.
That is the core of all of this.
I agree, Kathy, you can't touch that.
Be able to text, someone from the town.
yeah,
She's working on it.
Jim said the live stream is fine. but
Okay.
I'm telling him I'm trying to call IT.
Maybe it's something.
All right, so the live stream is okay, and we have a lot of business to get through, and I'm sure a lot of people, oh, yay.
Just
we
remember
go.
what you did for next time.
Just when we thought we were gonna have to scream.
Okay,
Just
so
scared the whole audience.
Comment.
All right.
Oh, yes, let's get back to Ms. Furman's comment.
Thank you. So we have two master plan consistency reviews tonight, and they are both land use issues. And for several months now, we've been going back and forth and not really making a decision as to whether an alternate vote should be made in the vacant Class 2 position. So I'd like to put forth a motion based on what the Hamilton Township trial court decided. And the motion would be to follow the court's legal opinion that was rendered in the Hamilton Township case, ruling that it was improper to permit an alternate to cast a vote in the place of a vacant position, as there is no absence or disqualification of a regular member. And that's straight from the court case, but I just want to protect us from any kind of legal thing down the road and just get it out on the table and take a vote. So I don't know if anybody is willing to second that before we go into any comments.
If you recall, Board, we had this conversation, and I thought that we had agreed on administrative functions such as what we're doing this evening, that the alternate could vote. I had conferred with Glenn Keynes of the Board of Adjustment and also the municipal attorney, Anand Das. The Sparta ordinance creating the planning board is a 9-person board, and therefore the functions of the Sparta Planning Board administratively is that we had discussed 9 members, and the alternate would be able to vote. The open issue is if an applicant comes forward under the Municipal Land Use Act, and I believe the Hamilton Mercer case was dealing with a formal application.
No, it was doing with master plan review.
Well, I'm still of the opinion that the board, even as the master plan and ordinances that are Sparta, it's my professional opinion that it is distinguishable from Hamilton Township. That was my prior opinion. It continues to be my opinion. And as to the municipal land use in which we have an applicant, I'm hoping that we will have a Class 2 member by our next meeting. But I do believe that we've already decided that administratively, you are 9 members and the alternate can vote. As to applicant work, I'm reserving my opinion until that occurs. So if you want to take a formal vote again on that, that is fine, but I'm continuing to rely upon that of which Mr. Keynes and Mr. Dash are in accord with.
Well, we never had a formal vote. Mr. Keynes and Mr. Dash, what they brought forth was the de facto officer doctrine, which is very, very different. That states that you can't challenge a person who's been in a position thinking that they were properly appointed. The people that we have as alternates are properly appointed, so we are not discussing that. What we are discussing is a vacant position, and the law, I thought, was pretty clear that an alternate votes in the absence or disqualification of a regular member. We have no regular member in that seat. We've been kicking the bucket down the road for many months now. No Class 2 has been appointed, and that's a separate issue, whether they're appointed or not. We have 8 regular members. So if there are no regular members absent or disqualified.
Yeah, but Joan, we have 9 members. Whether there is a vacancy in Class 2, I respect and understand the Hamilton Township case, which is advisory. It's not binding on us, and that may be applicable also, but here we have a function, we have a duty, you're 9 members, the public is entitled to 9 members, and I think it's proper to have 9 members vote. Your point is well taken, and the Hamilton Township case is there, but again, I'm of the belief that as far as these administrative non-applications, so let's say I'm representing an applicant and I'm seeking a variance or I'm seeking some type of land use site plan, I believe in those cases, it's distinguished that the Class 2 member should be appropriate. Here, on administrative functions, things that are referred, hiring of the attorney, hiring of the experts, the planner, there's 9 members here, and they should vote. As far as the ordinances, I believe that they are referred to us by way of the Sparta Planning Board, and there are 9 members who are eligible to vote here tonight. Again, I respect your position, and I'm reserving my opinion as to any formal applications, but administrative functions, I believe that we should act as 9 members. If you want to take a formal vote, so be it. That's no, there's no harm in getting the,
Yeah, we still have to determine this procedurally, whether we decide if this is administrative and we have a person voting tonight, that's fine. But I'd still want to get it on the table so we don't have to carry this another month.
So what are we actually voting on?
Well, first off, there may not be a vote if there's not a second. So there is a motion, but there's currently no second. So we can,
Okay, go through.
well, the question is whether or not someone is willing to second this motion. If there is, then there'll be discussion. If there isn't, then the discussion ends. So that's the question. There is a motion on the table. Is there a second?
Let me read it one more time then. Motion to follow the court's legal opinion rendered in the Hamilton Township case ruling that it was improper to permit an alternate to cast a vote in the place of a vacant position, as there is no absence or disqualification of a regular member. So if we get a second, we can discuss it. If not, I tried.
Hearing none, I think the issue is pretty well decided by Ken's interpretation, and I'm sure we'll revisit it again.
and hopefully the mayor and council will cure the issue. We won't have an issue in April.
But we
and that
still have an
vacancy.
issue because this is a procedural issue that I think we need to decide. It should be in our bylaws, and that's another thing that we should be working on.
So
You know,
noted.
we should know where we stand in this and not just kick it down the road and say, well, let's wait for town council to fill this position, because we've been doing that for months.
I
So,
understand.
That's
And
my
so-
opinion. I'll drop it.
And so noted, and again, I should add for the record, our past practice, even prior to me being here, was that the alternate was voting in that for at least the year since I've been here. So that's another factor that I would weigh in, but well noted, interesting issue, and again, hopefully the mayor and council will make it moot by appointing a Class 2 member. Thank you.
And I think it's now appropriate for us to move into the other board business, which starts with ordinance 2602, detention center prohibition and land use ordinance.
Board, this is an interesting issue. Your power as a planning board, and we have quite a few people in the audience today, and I'm sure online, is the mayor and council put forth an ordinance. And when an ordinance related to land use is referred to the planning board for a consistency hearing with the master plan, which is what we're doing today. Now, as to the second hearing, the fourth round amended fair housing plan, we have a written opinion from our planner as to that. As to the detention center, I have given you an attorney-client opinion letter, but in essence, if it was necessary, we could go into closed session. But the big picture, it's no surprise if you Google detention centers, we have the Roxbury issue, and Roxbury is against it. There's an issue called the Supremacy Clause in the federal court. The Supremacy Clause of the United States Constitution is Article 6, Clause 2, that states the Constitution, state constitution are subordinate to federal laws. But then we also look to the 10th Amendment to the federal courts, have to have the power that is delegated to them. So if you talk about immigration, you talk about federal prisons, let's assume that there is a power that the federal government has. When we look to state and our forefathers of federalism and the power of the states to regulate their own zoning, We look to that because the state and the town knows best what your public health, safety, and welfare constraints are. When you look at a warehouse that has 3 or 4 bathrooms in it because that's the type of operation versus a detention center that is now changing that use to impact other issues of public health safety. So the ordinance that is here before you is it consistent with the master plan? I would say that it's difficult for you to find this issue as we had with cannabis, detention centers. When I first started practicing law in the late 80s, early 90s, there was issues with go-go bars and First Amendments. Towns were zoning out go-go bars, and the applicants were saying you can't do that because of the First Amendment. It worked itself out, and I think the same thing here with detention centers. You have competing interests. I do believe that the ordinance is proper for the town of Sparta to give your opinion of whether you're favored or not. Are you going to find in your master plan the word detention center? I would think not, because it's something that was really just emerged in recent years. Is it inconsistent in the master plan? I don't believe it's inconsistent to prohibit certain uses. So as far as whether it's consistent with the master plan, it's my professional opinion that you could find that consistency, but those are the issues that have been raised of supremacy and preemption, and I've given you the contrary argument of public health safety. And the two have to be balanced, and just as the Class 2 vacancy seat, I may be wrong, I could be wrong here of the consistency, but it is here before you for consistency review. There is no real public review of it. The public review is at the second reading before the mayor and council. And as I've spoken to the chair, that if the public was here on the detention center as a professional courtesy, if they wanted to give a short position, I don't think that's improper, but there is no obligation of the planning board to give public comment, because all you are looking at on the detention center and the fair housing is it consistent with the master plan? You give that to the mayor and council, and there is a second reading of the ordinance on which the public can be heard before the mayor and council. So that is my overview. If there's any questions, through the chair.
I have one. When they're talking about detention centers, they're not talking about the local police department and their short-term detention, right?
Good point. Good point, Henry.
I don't know if there's anything in there.
There's an exemption or exclusion.
Is there exemption in there in the ordinance?
Mics, please.
Okay.
An exemption for what? I can't hear.
All right.
Our police department.
So again, Mr. Porter, I can. So the task in front of us is as simple, is it consistent or not? It's not, do you like it, do you approve it? It's, is it consistent with the master plan or not? And we say yes or no.
Correct.
Thank you.
And my opinion is you have broad latitude. Because you're not going to find it expressly in the master plan. As we didn't see cannabis and as we didn't see in years of old go-go bars and those type of issues. Thank you.
Any other questions or comments from the dais?
I would say it is consistent, because if you take a look at the vision of Sparta and what they want for Sparta, it is consistent with that portion of it.
And board, that type of testimony is helpful for the mayor and council if you find consistency. If you feel it's consistent, I'd recommend to you state why on the record, or there's no obligation to state, you can just vote yes or no. But that's a good comment, Ms. Furman.
What vision specifically, Joan, are you referring to?
Well, I can't state the vision offhand, but everything we've heard in doing the whole master plan, and what we do have in the master plan, is people want to maintain a rural character, a community sense, and this would not fit into what that vision is for Sparta.
I think in addition to that, we're always talking about traffic, especially when we're talking about large buildings, warehouses. A detention center would have an enormous amount of in
And it
out
would have it
traffic.
24/7.
But let me just ask a question, I guess, to Ken. are we applying this ordinance to the existing master plan that's in effect in the governing master plan as we speak, or a somewhat in the near future or down the road, a new master plan? Which, I would assume that this is applying to the current master plan in place. So
That is
If
correct.
you want to restate or reconsider getting clarification on that, vision's one thing. We got to operate within what's in front of us, right? So
But it was in our prior vision as well.
there was some changes and modifications to that. There was a previous master plan that then was revised. I've lived this, right? I mean,
Yeah, I know.
And then it's dealing with what's in front of us with this master plan. Now, if we want to create and have what we've been talking about over the last several months, year or so with doing a new master plan, and so be it. But I just want to make it clear that this ordinance, at the time we're discussing it, is applicable to the current master plan in place.
Yes, it is. The current master plan in place. I do also add, though, that you are well into the new master plan, and there has been public comment, and there has been drafts. Not that they are binding, but I do believe that the relevancy of the current situation, so we're looking for consistency with the master plan, with also, as of today, the March 4th reviewing of knowledge you have going forward. I don't think it's improper, Deputy Mayor, to look at what your current situation is. But technically, you are absolutely correct. You look to the existing master plan. We have not passed the current one.
I know Lindsay's been working on this like nonstop here. Do you have the old master plan? By any chance, like readily available on your computer or anything?
I could pull it up on my computer.
Yeah,
Yes, I can pull it up.
just so we're making
well,
sure here.
Lindsay, you don't carry that in your back pocket?
Section 5 says that the ordinance shall take effect 20 days after final passage and publication as prescribed by law.
Correct.
So after 20 days, once it's passed, so then that would suggest that it would be included in any future master plans.
It's when it's adopted by the council. So it goes from us back to the council for a hearing of the ordinance and then a vote on adoption, and then 20 days after that.
Right, after final passage.
I mean, Lindsay, you're living the master plan. Do you have any comments in general on the existing master plan and the goals and objectives we're looking at now?
Yeah, absolutely. So a lot of the previous master plan, some of the goals and objectives were about maintaining kind of the balance between the natural resources within Sparta, as well as maintaining kind of the similar residential structures, as well as maintaining, that quintessential downtown. That is continuing into a lot of the goals and objectives from the original master plan are very similar to the goals and objectives that we will be probably having in this newer master plan, obviously updated. But a lot of it is about having sustainable growth, having traffic, as you learned from the previous meeting, is a hot topic for this upcoming master plan. The previous master plan obviously touched on traffic, but not quite as much because so much has changed since then. But a big portion is in the previous master plan is about maintaining the character, maintaining the natural resources, making sure that there is that harmonious balance between the two as well.
And if I could, Chair and Board, we are very fortunate tonight to have in the audience Catherine Sarmad with regard to her efforts and her experience with the existing master plan. Catherine, I don't know if you have anything you want to add on detention centers that could help us? Sorry to put you on the spot.
Do you want me to swear in, by the way?
You solemnly swear to tell the whole truth, and nothing but the truth, so help you God.
I do.
Name and professional address, please.
Catherine Saramad, 26 King George Road, Warren, New Jersey. Thank you.
Can you help us out?
So I agree with Lindsay's characterization of the master plan goals, and I agree with your background that, the master plan likely doesn't include that specifically, a specific recommendation about detention centers or anything of the like. But I do think that a characterization of the goals and objectives that was stated captures that it's probably something that Sparta never kind of wanted. So it wouldn't be something that would be in those documents as something, a goal. And so additionally, and I'll talk about it when I go through the next ordinance, is the board is supposed to identify through the MLUL provision of the referral powers whether or not the ordinance has inconsistencies with the master plan. So it's kind of like a double negative. You're finding that it's not inconsistent with the master plan, and therefore the ordinance and what it proposes is not inconsistent with the goals and objectives of the master plan. And I think hopefully that will be helpful to the board.
Good point. And Lindsay, would you mind solemnly swear to tell the truth, whole truth, and nothing but the truth shall be God?
I do.
And you had given some testimony about detention center, is that's still accurate?
Yeah, that's still accurate.
And as far as the comments of Ms. Sarmad, as far as the inconsistency, can you elaborate on that also? That an ordinance that's not inconsistent with the master plan?
Yes, so we are looking at the ordinance this evening as if it was consistent with the master plan, saying that detention centers are not within the comprehensive master plan, or the reexamination reports. Obviously, the use was not a use that was contemplated. It's never been implemented in any zoning. And in addition, much of the goals and objectives do not align with this type of use.
And in your opinion, is the ordinance proposed, therefore, is not inconsistent with the existing master plan, in your professional opinion?
It is not inconsistent.
Yeah, thank you. I have nothing further, Board, on detention center ordinance.
Just to add, the 2020 reexamination report gave some updated elements and vision, and it dealt with controlling some of the things, controlling intensity, Route 15 corridor, open space. So just to put it on the record that it is consistent with those.
Good point.
I have a question. So in the past, when it comes to really putting ordinances, especially ones that are sensitive like this one, to give them the teeth to be able to really to hold up, right? In the past, we had gotten guidance from legal counsel to say, instead of putting it in like a land use component, really focus in on safety and security, because if you can pull it out of land use and you can frame it so that it is it's a safety hazard to residents, it's a safety hazard to the environment, or not even you could use that too, but you could also say to the people that would be housed there, because we don't have the proper infrastructure to support it. So my question is it better for this, given the, to give it more teeth, to be able to stand, if it is challenged at any point in time, to add some of that verbiage in here? I think, what I'm hearing is, and what I feel is, this is absolutely consistent with everything that everyone wants. My concern is, what can we do so that it holds up if it's challenged?
Yeah, good point, as your experience as a past mayor and your involvement is spot on. I would say that we add to our position, and I would help frame this for the mayor and council, that in addition to the comments, there is a large concern for public health and safety as to the hazardous conditions that this would create. So yes, Mayor, this creates another argument.
Okay.
And Ken, in addition, I can prepare a memo back to mayor and council, just citing different areas of the master plans and the reexamination reports, identifying how this ordinance is consistent with those as well.
That would be helpful. Thank you.
Thanks for the support. I'm just trying to make sure that we can do everything possible to make sure it holds up.
Okay.
Any other questions or comments from the dais?
Just to pick up on that, so if you're gonna tighten it up, do the rebuttal of that. Has that been challenged in court that in fact the detention center, it's got heavy security, heavy XYZ, working with community police, et cetera? Does that safety argument hold up, or has that been challenged in court? Because I've seen it both ways in my research on it and my discussions. Not debating it, I'm just putting it out there. If we're gonna try to change that to put teeth in it, want to make sure that's been challenged and/or we could check the box on that.
Yes, Deputy Mayor, I believe we've checked the box and we're okay. It's such a hot issue. I mean, Roxbury is on the cutting edge right now. There was an issue in Newark, and they actually, as I understand it, settled it. One issue that we're also discussing is regionalization of a need. So, again, this goes back historically, the law dealing with if there is a detention center, let's say in Newton. Newton has a county jail that is, I understand, vacant and available. Does that satisfy the needs of the region? That may be another support for why not Sparta? All great points. I'm not aware of any cases right on point at this time because it's so current.
Okay?
And just to make sure that we are crossing the Ts, dotting the Is, going back to what Ernie was saying, there really is no carve-out in here for the local jails. So if we're going to be rewriting it or we're not rewriting, if we're making a recommendation, I would like that to be one of the considerations that goes in our report.
So we can put, if it's not very clear in that, that we will recommend that to the mayor and council in our recommendation. So I think the proper, Chair, that again, there's no public referral on this because it's referred to you for consistency. I think it's proper to have a vote now on this issue. If someone in the public wanted to talk about that at the open portion, they're welcome. If the board wanted public comment now, but you have a long agenda, it's up to you what you want to do.
What are your thoughts? Now or no? Okay. So, as courtesy to the public, since you are all here, I will open it to the public for comments or questions. Please, given the volume of people in the room, be as brief as possible, but this is your opportunity to have any conversation that needs to be had relative to Ordinance 2602, specific to detention, to the detention center ordinance.
And not a for or against, just consistency with master plan.
Right, but this is their ability to comment, so we
Right.
kind of can't really tell them what they can and can't say. We may not be able to answer them, that may be better suited for the council, but I do want to give people an opportunity to speak, they're in the room. Okay, seeing none, we will move forward to a roll call vote. So Ken, if you wouldn't mind
Yes.
fashioning the motion so that we can have a motion in a second.
Yes, you have before you a referral on ordinance 26-02, detention center prohibition land use ordinance. There was some discussion as to consistency with the master plan as well as that it's not inconsistent with the master plan. There was discussion to make sure that the reference to a local jail detention is an exception, and the board planner, Lindsay Knight, said she would supplement the determination with a written memorandum as to the same, if someone would move that motion.
Second.
Okay, so everyone knows what they're voting on. We are voting,
That ordinance 26-02 with those amendments and clarifications are consistent with the Sparta master plan and also found not to be inconsistent with the master plan because detention centers are a relatively new land use issue.
okay.
And making the carve out for the local police
Yes.
department.
Yes,
And also adding new components for teeth, safety, and security, right?
yes. Good.
Let me have a roll call, please.
Christine Quinn,
Yes.
Deputy Mayor Mike Sylvester,
Yes.
Ron Day,
Yes.
Christine Dunbar,
Yes.
Joan Furman,
Yes.
Ernie Ragsdale,
Yes.
Brian Zimmerman,
Yes.
Birgit Bogler,
Yes.
Vice Chairwoman Jeanette Burke,
Yes.
Chairwoman Celeste Luciano.
Yes.
Okay.
Okay. Moving forward to ordinance 2603, Sparta, fourth round amended fair housing plan for review and possible action.
Yes, Board, you have before you a second ordinance dealing with land use. This one, what I'd recommend, we have a analysis from the professional planner handling the fair housing, and very astute, Catherine, through the chair and the board, has given us a written analysis, and if you can present that, please.
Thank you, Mr. Porro. Thank you, Chairman Luciano. And I just wanted, the characterization on the agenda is a little bit off because this is not an ordinance related to the amended fair housing plan. This is an ordinance that repeals and replaces existing sections of the affordable housing ordinance within the township code. Ordinance number 26-03 was transmitted by the Township Council to this board on February 25th. It was introduced on February 24th on first reading. As I mentioned before, the MLUL vests referral powers within the planning board. So after it's been referred to the planning board within 35 days, the planning board must determine if there are any inconsistencies with the master plan in the ordinance and to transmit any of those findings back to the council, or otherwise provide a transmittal back that includes that the ordinance is not inconsistent with the master plan. So I had an opportunity to review the last two master plan documents that have been adopted, which are the 2020 Master Plan Reexamination Report, as well as the fourth round Housing and Fair Share Plan that was adopted last June by this board. In a review of the 2020 Master Plan Reexamination Report, it does provide a background of basically the master planning history, the Master Plan Reexamination Report history, and all the elements that were adopted. And it also, as it relates to the subject ordinance, provides in that Master Plan Reexamination Report, an update about the 2016 Housing Element Fair Share Plan, which was the third round Housing Element Fair Share Plan, which established the objectives and goals related to affordable housing, and talked about how the township intended at the time to prepare and present a housing element and fair share plan amendment that would meet the court's approval. And so essentially it was discussing that the township was working towards compliance in the third round through the 2016 Housing Element Fair Share Plan. Upon review of the 2025 fourth round Housing Element Fair Share Plan, that plan was prepared and adopted within accordance of the amended Fair Housing Act that was signed in to law in 2024. That has certain requirements for housing elements in order to provide housing opportunities for low and moderate income housing. And that housing element addressed the particular amendments to the municipal land use law through the amended Fair Housing Act. Separate from the amended Fair Housing Act, there was a new process established by this fourth round by the amended Fair Housing Act, and also established an administrative directive that was provided in December of 2024 that was called Administrative Directive 14-24. That included specific requirements separate from the law, separate from the MLUL, that established all of the requirements that are included basically in a compliance package with a Housing Element Fair Share Plan. So it notes some of the appendices, which I listed in the review, including an affordable housing ordinance that basically sets forth the provisions for monitoring, reporting, different requirements regarding very low-income housing, very low-income affordability, as well as annual increases in rent calculation, et cetera. Also requires the adoption of a mandatory set-aside ordinance, if any, and the execution and update of a development fee ordinance. So all of those are requirements that all municipalities throughout the state that are participating in this process are required to have a compliant Housing Element Fair Share Plan. And so as part of that process and by law and that directive, the township is required to update its affordable housing ordinance, development fee ordinance, and mandatory set-aside ordinance. All of these ordinances codify various state-level regulations that were just updated about 3 months ago. Mid-December, the Uniform Housing Affordability Controls were updated, also known as the UHAC regulations, as well as the DCA regulations under the Local Planning Services, which is now known as 5:99. They're just called the new rules. They're not called the fourth round rules. They're the adopted new rules. And so the ordinance basically has to codify what are state level regulations. There's some options for municipalities that were part of that model ordinance. But for the most part, it's a codification of regulations that the township would have to abide by anyway, and it's just a local ordinance that then enforces it. Finally, the Housing and Fair Share Plan that was adopted included a section called Development Fee Ordinance and Spending Plan, and it discussed that the township has an existing development fee ordinance and would be updating its spending plan in the adopted version once it was adopted by the council, because that is a document that's adopted by resolution by the township governing body. Finally, separate from the master plan review, most recently, the township did receive through this amended Fair Housing Act process called the Affordable Housing Dispute Resolution Program, did receive a program judge recommendation that was on February 5th, and most recently yesterday on March 3rd, received a program decision and order from Judge Allen. And that also has implications about this ordinance being adopted, as it is part of compliance and part of that judgment to determine if the township has a compliant housing on fair share plan. So overall, my findings are that Ordinance 26-03 implements the requirements of the fourth round Housing on Fair Share Plan, which has been adopted to address the amended Fair Housing Act as well as Administrative Directive 14-24. This ordinance, substance-wise, covers a lot of the topics that are already in the Township Code under Section 18-8.4, which is the development fee ordinance right now, 18-8.5, which includes affordable housing regulations, and additionally does supersede 18-4.2Q, which right now is under general provisions. Mr. Day brought that up to me. We forgot to put in the ordinance the repeal of that, but the repealer clause at the end of the ordinance does say that any provisions that are basically more up to date that would supersede these. So the repealer clause will basically just repeal Section 18-4.2Q as well and supersede it. You'll notice if you go to that section of the ordinance, if you have time, it's about 5 pages long. This ordinance is 40 pages long, I think, and that is no fault of the township. Unfortunately, at this stage of having 4 rounds of regulations, a new adopted UHAC set of regulations, and the form of ordinance that the powers that be at the state wanted, the ordinance includes 13 to 15 pages of definitions. It includes every reference or every actual regulatory provision, not just references to the state codes. And so it becomes very bloated and very big. But now you don't have to go searching through the state codes. You have it right in your own ordinance, albeit that it's very, very long. But other than that, I do think that upon review of these master plan documents, that this ordinance is consistent with the town's master plan. And I do want to note that in repealing Section 18-8.5, there is a provision right now within the township code that does allow for incentive zoning throughout most of the town center zones. That is also being repealed, which has been recommended by the program judge to repeal the town center overlay zone ordinance in an effort to preserve the township sewer capacity for other affordable housing sites that were in the plan. And so based on a lack of sewer capacity that has been recommended by the program judge, allowed. And so it is part of the affordable housing sections right now. So as part of the ordinance, you also notice it's obviously not in here because it's being repealed, but it's no longer going to be active. It's no longer going to be a provision of the ordinance any longer. And so, again, to summarize, I do believe that the ordinance is consistent with the 2020 Master Plan Reexamination Report as well as the 2025 Fair Share, fourth round Housing Element and Fair Share Plan. And I would take any questions from the board and recommend that the planning board transmit their findings back to the council.
If I could, before we get to the board, just the catch-22 for us is that it's an unfair system. And it's an unfair system because the New Jersey legislation has not acted. So by the New Jersey legislation not acting, the New Jersey courts got involved. And what I mean by that is that we used to have something called COA, the Council on Affordable Housing. It goes back way before Governor Chris Christie. And what happened was, at some point, those seats were not filled. It was not functional. It was not operating. The courts had said if you do not take action, the court will take action. The legislation did not take action. And that's why we have in New Jersey, our Constitution finds an obligation for fair housing. That is a constitutional right that New Jersey has found. Other states have said you can't discriminate based upon gender, race, and the like, but does not require it as a constitutional requirement. So that's unique to New Jersey, and that's why the New Jersey courts have stepped in. We have the executive branch, which is the governor. You have the legislative branch, which is supposed to be passing laws. And then you have the judiciary that reviews those determinations, whether it's constitutional or not. Well, the court is unique in New Jersey, has stepped in and said for years, legislation, you have to act. It doesn't matter if you're Republican or Democrat, nothing happened. The court now intervened and put these very strict deadlines. And one of the deadlines before us is March 15th of 2026. And that's why we're seeing the consistency here. The courts want to see good faith. There are what's called land use adjudicators that have been appointed throughout the state. Every town is subject to this. If you do not act with a plan, you are subject to what's called a developer suit. If you come in with a plan, you have immunity from those suits, and it's a very good process by way of, you've heard the third round, this is the fourth round, which is good for 10 years. 2025 to 2035. And then what happens is after 5 years, there's kind of a monitoring to see that things are going the way they were, so you can change things. And then the fifth round will come in 2035, 36. So the important thing to remember here tonight is that the plan that's submitted, if it's not passed, could affect whether or not you have immunity. And now let's say the plan says in a particular community, there's going to be 40 units in this location. There can be 15 units in another location. If that plan that Sparta has put forth is not passed and you don't have immunity, that property owner could come in and say, you know something, it's nice you're going to give me 15, 12 units, but you don't have immunity. I want 40 units. Oh, it's nice you were going to give me 100 units in that area, but you don't have immunity, you don't have acceptable, I want 200 units. So it's always recommended, even though it's sometimes tough to swallow on the, or accept the housing plan, because you're seeing more units. The alternative is not having immunity and being subject to additional units. So that's just my legal opinion. As similar to the detention center, this matter is referred to you for consistency. You have the written report from our professional planner on the housing. You do not have to let the public speak. However, as you did with the detention center, you have a number of people here, but recognize in the public that we are only here to see if it's consistent. Now, remember on the master plan, that deals with zoning, it deals with traffic, it deals with what our vision is for Sparta. One of the elements in the master plan is specifically housing. So in my professional opinion, it is almost impossible for this board to not find a plan consistent, because any plan that deals with housing is consistent with the master plan element. Now, the plan that's here has density requirements, X units in particular zone.
Ken?
Yeah.
Sorry to interrupt. This is just the ordinance. This is not site-specific. This is not obligation-specific. This is simply the regulatory requirements and the monitoring and administration of the units. So I would just limit the questions to that as it relates to the ordinance itself, because we could go far afield with a lot of affordable housing stuff.
Very good point. Thank you for the clarification. So if you look at what's been sent to us, it's, as Catherine is saying, that we're complying with the new regulations to say that our plan will comply with it, we'll have a spending plan, we'll do what we're supposed to do. And I know that some of the issues in your neighborhood may be, at the end of the day, there are so many units in this location, so we are not, as the planner said, we are only reviewing today that we are going to comply with the New Jersey laws consistency. Ms. Catherine?
We will open it up to the dais for questions and comments.
Just one comment if I could. Catherine, if you could, also have them take a look at section 228. I think there might be some duplication there.
220, you said?
2-28,
Dash.
municipal housing liaison. Just so there's no inconsistency between the definitions.
Okay, thank you.
Just to clarify too, you're saying that this is not specific to any particular zone. This is an open document. It'll be refined later on. Because one of the things that I want to clarify is, as we all know, we are paying for a lot of flow in this township when it comes to sewer, and we are not realizing what we're paying for. So water's upside down. It would be very good if we were getting units in that did not need to rely on having their own septic systems, the huge septic systems having to be put in place, if they could leverage sewer, because what that does is obviously it's going to help us reach our flow, and it's also going to reduce the cost for the citizens that are already paying it now. So I want to just clarify what you said, because it sounds like they took it out, but for us, it sounds like that might be a good incentive for the rest of the residents.
So without getting too deeply into the actual housing element, which will be back before this board, just to give an update, the program decision and order that was issued did give an extension from March 15th to April 30th for the township to act. There will be other items that I will be here, including an amended housing element, so we'll get a full discussion on that. This ordinance is simply, like I said, not site-specific, largely not even Sparta-specific. It is really it gives the authority for the township to collect development fees and to have an active spending plan that will be able to spend them from an affordable housing trust fund. It empowers the township to have an administrative agent, a municipal housing. It basically, the administration and how units get filled and how people get income qualified and how many units have to be very low, or moderate, that's established all in this ordinance. It's basically the rule book for how affordable housing needs to get developed to be compliant with the state level regulations, as well as how it needs to be continued to be monitored and implemented over time. It is not even plan specific. It is really about, like I said, administering affordable housing as a very global idea.
So I have a lot of questions that are specific to what's included. I'm going to save those for when you come back, right? Sounds like?
That's
But I
a
do
good
have
idea.
one question that I want to clarify with you, and that is around the administration. So there is I think there's a lot of, we could do a good job with the community here clarifying two things. That affordable housing is not Section 8 housing. That's the first thing I think that that I know for me was big, aha moment many years ago. But the other thing is as well, when it comes to the area for which this affordable housing is, a lot of people think, oh, good, we're going to have 100 units and that will be for our seniors or our young people or our whatever. But there's a process of administration behind that, and there's a district that we're assigned to. So what district are we now, through this ordinance, assigned to where they get the notification and they get the first couple spots before, where it's advertised before it comes to Sparta? I'm just curious, because it used to be like Bergen, Hudson, and Essex.
Correct. Sparta is located in Region 1. Every county is in a region. So Sussex County is in Region 1, which I believe is Sussex, Bergen,
Hudson,
Essex.
Passaic?
I believe so.
Bergen,
Yes.
Hudson, and Passaic.
Yes, and
That's what I
so
wanna clarify.
it is a lottery process. The township has an administrative agent, a very good one. There's people who submit an application. They have to submit a lot of documentation to income qualify, and they get put on a waiting list for units that come up, and they get to go tour the unit. the unit's marketed and then they go toward it. If it fits their needs for their family, you know, depending on how many kids they have and things like that, they can either decide to move forward with it or not, or get put back on the wait list if they don't. And every unit, let's say it's a 2-bedroom unit, it has an income level associated with it. So it's not floating. It is a low mod or very low for the lifetime of the unit. So that's why when someone gets put on that wait list, they have to meet that certain income qualification. Now, it's not Section 8, it's not a voucher program. These are income levels that are determined by the area median income, which in some cases are over 100,000 for the area median income. A moderate income unit for a person in Region 1, I think, can be as much as 80,000, and it goes up, you know, by the size of the household, and it probably goes down to, let's say, 35 or 40,000. So it's not someone who has no income. It's a low income. It's someone who has income. It just happens to be lower than the area median income. And so, you know, you could think about it as housing for, you know, teachers or police officers or single parents, things like that. So that's often how, you know, I like to characterize it and to kind of quell any misconceptions that it's a voucher or Section 8 program.
Also for seniors, veterans, and also for new families coming here, right? That just get brand new jobs or just get out of college, that hopefully this will keep them here. So thank you for clarifying, because I think that's a big misconception. And also, thank you for clarifying the region that we're in. And I'm going to save the rest of my questions, Madam Chair, for the next round. I'm sure you're very excited about that, but I'm going to share them for the next time you come. I'll save them.
So Catherine, the next round is really the meat and potatoes of what the plan is.
Correct.
This is on your report, you have page 3, that this is in compliance with the NJAC, New Jersey Administrative Code. I think you called it UHAC, and basically saying these are the new regulations for Sparta to be in compliance and get immunity. We need to have ordinances that comply with the regulations.
Yes, there's pretty much every municipality is dealing with a laundry list of things they need to get done. Luckily, Sparta was afforded another 6 weeks because it's under ongoing dispute, which is outlined in that order. But every municipality basically has a laundry list of, you know, ordinances they have to adopt, plans they have to amend between the planning board and their governing bodies. So Sparta's not alone. This is just one step, but it was a step that we get it done, and then it's out of the way, and we can focus on all the other items that need to get completed.
So again, if someone in the public comes up and says, in my neighborhood, I hear this development is coming up, that is not tonight.
Not this evening, no.
Okay.
In the future, there will be an opportunity, though.
Any other questions or comments from the dais?
Yeah, I have some questions. So under section F, low/moderate split and bedroom distribution, it's,
Yes,
okay.
and it's not
So-
posted on page number.
Affordable units shall be divided equally between low and moderate income units. Then number 2, in each affordable housing development, at least 50% of the restricted units within each bedroom distribution, rounded up to the nearest whole number, shall be very low or low income. Then under section 4, part 2, it gets very specific. 2-bedroom and/or 3-bedroom units compose at least 50% of all restricted units. Then the combined number of efficiency and 1-bedroom units shall be no greater than 20%, rounded down. Then it goes on, at least 30% of all low and moderate income units rounded up shall be 2-bedroom units. And then it goes on, at least 20% of all low and moderate income units rounded up shall be 3-bedroom units. Is this a one-size-fits-all approach that every single town has to adopt in order to get immunity? And what does that immunity actually come with?
Sure. So this requirement is basically for all new construction moving forward to make sure that a project's affordable housing set aside meets certain income and bedroom distribution requirements. And I'll give you an example of why that is. Before there were regulations that established this, a developer may have an inclusionary project with an affordable set aside. Let's say it's a 100-unit project and 15 units are affordable. To fit them into the project, and have it almost be an afterthought, 15 of those units would be one-bedroom units. And they'd make them all moderate income because that had the least impact on the amount of money that the developer would make or lose on subsidizing those units in the development. And so as a way to make sure that 3-bedroom units for families got built, that 2-bedroom units for families got built, at different income levels, like very, very low, which is 30% or of the area median income, or moderate income units, which are below 80%, to make sure that that entire spectrum got captured and basically held developers to these requirements, they put them into the what are called the UHAC regulations. And so there might be a deviation, or a developer may request a deviation. I've seen that happen over time, but the township has an obligation at the overall global plan to meet these income distributions and bedroom distributions overall, so that there aren't too many 1-bedrooms or there aren't too few 3-bedrooms. And so it helps keep everyone in line. As far as the, what's at stake here and having immunity, Ken talked about it a little bit. There are what's called builder's remedy lawsuits. And so for towns that do not have immunity from builder's remedy lawsuits because they don't have a compliant plan, either they didn't participate in the whatever round, or they didn't, or they pulled out of that process, or, they fought the process, they could essentially lose their zoning powers through builder's remedy coming in, where rather than an application coming before a planning board, they would go before a court. So most recent examples in the 3rd round, Englewood Cliffs, South Brunswick. You can see what happened in those litigations. Costly litigation, and costly to the town's zoning powers, which, every town has home rule and has the power to zone through the state constitution. And you don't want to lose that, because you get to choose what's permitted in zones and how dense things are and all those things. And if you lose it, then you lose that power to do so.
And as Catherine said, the outcome in Englewood Cliff and which Brunswick? was
South
it?
Brunswick.
South Brunswick was not good for the community. It did not go well. Thank you.
Can I ask you also, and I know I hate to put you on the spot, but I think it's really important, and I think it fits in with this conversation. When we're talking, there's been so many numbers flown around, and I really hate to put you on the spot because I know it's super complex and very confusing, but can you just sort of break down where we are in the process and what number of units we're talking about? Just so everyone is clear on kind of, there's been so many numbers floating around out there, and I know when you go through each round, and then you can defer units, and you can, we've been negotiating and trying to renegotiate. Can you just give us an idea of what we're looking at here, what we're talking about?
All right, Catherine, before you answer that, I think it's important to note, though, that any development, the most important question is, it used to be 15% set aside, now it's 20%. So as far as if the public hears a number that you're offended by, that's just the number that the formula has determined. The municipality takes that number and looks at what is feasible based upon your sewer, based upon other issues. So don't hear that number and just cringe, but go ahead, Catherine.
Maybe you're not in a place to answer that, and if you're not, that's a good answer too, because I don't want incorrect information getting out there either. So I don't want to put you on the spot. If you are not in a place and you're in the middle of these, going back and forth, that's totally fine as well. We can talk about it down the road. It doesn't sound like we need that information for this discussion tonight.
I just want to make it, if in your community you hear that they're going to have 100 units, the UHAC, the new regulations is at 20% set aside, 80% is market. If you hear that a unit has 10 units, 20% is 2 of that. So it really, what happens, gang, is that when you don't have a plan, these smaller, and I lived in my professional career, I grew up in Rutherford and Bergen County, and there was an application that was there for some 20 units, and the town denied it. And now there's some 100 and some units at that location, because now they have a requirement. So you have to be reasonable in what is being built in your community, and don't take offense by the 20%, look to the density and the traffic, and if that's a reasonable site for it. Catherine, go ahead, please.
I'm going to defer that conversation just to the housing element. I think we can have a, a larger and better discussion when everything's on the table rather than just throw out the numbers of like what our third and fourth round obligations are, because that's not the full picture.
Okay, I think that's completely fair. I just wanted to ask the question and get it out there. You want to?
Yeah. So Catherine, first off, thanks for explaining everything, and hopefully the public is taking it all in as well. It gets complicated and confusing, so I thought Ken and you did a great job in trying to make everybody understand. It's a complex issue. My question is, passing this tonight to be compliant with the 15th, which is now extended, is what I heard, gives us immunity. If by chance we don't hit our numbers, does that immunity go away over that period of time that Ken explained?
So so this is one part of compliance, right? This is like, these are ordinances attached to the housing element. The housing element itself will be found to be compliant or not.
Okay.
We'll get a compliance certification at the end of this process, hopefully if all goes correctly by April 30th. And we adopt everything. Your plan then for the next 10 years has that compliance certification and that immunity. I believe that I don't remember if it's a legislation or, Fair Share Housing Center is a group that's been part of a lot of what are called settlement agreements or mediation agreements through this process in other municipalities, not here in Sparta. We didn't get to that level, but they have been putting in a requirement for what's called a midpoint review. So in 2030 or so, it gives them the opportunity to look at what still presents what they call a realistic opportunity, which is not a heavy burden to prove or not, because in most cases, to have zoning for 3 or 4 years is not a long time in New Jersey to get through, regulatory approvals. But it does give, if there is a settlement with Fair Share, the opportunity to look at the plan in 5 years, but it doesn't remove the township's immunity. That this plan, if it is adopted, when it's amended and, it gets certification, is a 10-year plan, is
All
a
right, so
10-year
just
certification.
let me just expand on that then. So, great. We're in compliance. Terrific. We're moving along. We do our midpoint check. We're lagging. We're close, maybe not close to the number, whatever. Can they affect builder's remedy onto us to accelerate that at that point, or is this stick?
So
Based on our performance over
Yeah.
that 0 to 10-year window, can they change that, call it immunity regardless of compliance, but can they come back and effectuate builder's remedy?
so that they cannot take away your immunity.
Okay,
But in only one municipality I ever represented happened to be Mount Laurel, where all this generated from. At the midpoint review, the township actually took the opportunity. They had some mechanisms in their plan that were not feasible financially, and they took the opportunity to shuffle some stuff around. But as far as, I think it's going to be very circumstantial in 5 years what it looks like. Let's say, and not to get again too in the weeds, Sparta is seeking a durational adjustment for sewer capacity. Let's say the whole town gets sewer. That's a changed circumstance that may change what's going on in 5 years and what our plan looks like. Not to say that it will happen. I'm just saying, I'm giving an example,
As an example.
of something
Okay.
that may happen.
I
So,
think you answered it.
thank you.
Thank you.
I have a quick question. The residential development fees that go towards the Affordable Housing Trust Fund, what is that and where does that go?
So the township, probably since, I don't know the exact year, probably the mid-2000s, early to mid-2000s, has had what's called an Affordable Housing Trust Fund. It's an interest-bearing account. It's a separate account. It can be utilized to pay for affordable housing projects, like the actual construction of projects. Sparta has utilized it for a number of group homes, developmentally disabled units, for 100% affordable developments where it helps to subsidize the construction. It also pays for professional fees, like in the preparation of some of these documents, it can be paid for up to 20% of administration, and has some requirements as far as how quickly it needs to be spent, that it can't just, sit there. But those fees are assessed off of When there is a residential improvement, it's based off the change in the assessed value. So not the overall assessed value of the home. Let's say the home assessment goes from 200,000 to 300,000 based on the improvements. The construction department and the tax assessor determine the change in assessment, and then they base the 1.5% fee off of that change in assessment. It goes to that fund. Half of it gets paid at time of the building permit, and half of it gets paid at time of the CO. That trust fund is monitored through, you'll see it, the spending plan eventually. It hasn't been prepared yet, but there is basically a 10-year spending plan. It's not a strong budget. It just basically outlines how the township is allowed to or foresees spending that money over the next 10 years.
But it goes to the town. That's really what I want.
It's from the developers or residential homeowners and it's the township's trust fund.
If I can just add on the resident developer fees, it really is a great mechanism. Other municipalities, Paramus built a veterans apartment complex with their money. South Hackensack put a senior housing building with that money. So let's say you're building a warehouse in Sparta, and it's a $10 million warehouse, 1.5, that's the cost of the house and the assessment. That money goes into this fund, and as Catherine said, though, it just can't sit there. But the municipalities are really good. They utilize that money. There can be rehab programs of people in need. So the concept is very good on the redevelopment. Thank you.
Thank you.
Could you go over local incentives that we had? Are they gone now? The density bonuses, the 4 stories?
Yes.
The bonus
Yes.
credits?
That's been repealed entirely.
Also gone is the ability to sell or pay, let's say, another community or a city to take your unit. So in days of old, let's say Newark would take X dollars from Sparta and take care of your obligation. The new regulations prohibit that completely.
It's called an RCA, yeah. It was basically a transfer of your affordable housing obligation to a city or an urban area. But yes, I should correct my statement. It is proposed to be repealed by this ordinance. So upon adoption, it would be fully repealed. That section would be fully repealed.
Okay, so instead of 4 stories, it would be 3?
It would be 0. The entire incentive ordinance is entirely repealed.
Okay.
So it would revert back to whatever the
It was-
building code is for that zone.
Yeah.
It was an overlay zone, so all of the underlying zones that overlay zone referred to or allowed, basically just takes the overlay, and the underlying zone is now the only thing that's permitted. So that was on top of whatever was permitted in the zone. So removing it doesn't change any, of the as-of-right zone allowances. The incentives are now just taken away or just gone.
So, but if somebody has the 4 stories, it's grandfathered.
If they did receive approval and time of application would dictate that, yes, they've preserved that.
If it's being used for that,
Correct.
if it's being used for that.
So since we were talking earlier about misconceptions about income, I pulled up the Affordable Housing Professionals of New Jersey 2024 Affordable Housing Regional Income Limits by household size. And Sussex County is in Region 1, along with Bergen, Hudson, and Passaic. Am I correct in thinking that the region's median income is what we would be using in Sparta?
It's what the income levels are based on. So the numbers
Right.
you see in that table, like as you go across, are actually the income limit for each of those categories.
Right, I'm getting to that.
Yeah.
The regional asset limit is 232,836. So anyone qualifying both on the income limit must also have less than that in assets.
Correct.
And the reason why I pulled this was because I read this week's Sparta Independent, and I always love the viewpoints letters to the editor. And this one caught my eye, and at first I didn't think it was going to end this way, but I'm going to read it. Article on prices was misleading by Michael Brinster from Wantage. I am commenting on the second article I've read in Advertiser News entitled, "Are Prices Really Increasing?" Including egg prices in this comparison is misleading and skews the results. Egg prices were inflated because of the bird flu, where nearly 100 million chickens were destroyed or culled, if you prefer, in the U.S. alone. It has nothing to do with inflation. This artificially increased egg prices substantially. Shame on the author for including eggs in this article. Conversely, selecting prices on the limited number of items that have been consistent lately also skews the results. And yes, the cost of food is rising at unacceptable levels, no question about it. What about a simple meat and cheese breakfast sandwich where you now pay $9.75? Give me a break. Everything is out of control. For crying out loud, I recently paid over $29 for a pizza. Vehicles, food, snacks, credit card interest, medical, streaming, rent, utilities, and almost every commodity is increasing. And this is the part as to why that prompted me to pull this document. I don't know how the young people can possibly afford rent, utilities, and food today in order to leave the comfort of their parents' home anymore. So I pulled up the numbers because I was like, well, what is a moderate income limit for one person, fresh out of college, graduates, gets a good job? A one-person moderate income housing limit to qualify would have to earn $67,431 maximum. To qualify for low-income housing, they can only earn $42,144, and for very low housing, they would have to earn $25,286 or less. The numbers for a two-person for a young couple go up slightly, but it made me think, you know, when these rules were written, and you said something about 2016, that you also reviewed something from 2016. What was that?
In 2016, the Township of Sparta signed a settlement agreement for its third round obligation. So these are going in 10-year cycles. The third round ran from 2015 to 2025. So that was the third round settlement agreement.
Because Sparta didn't meet the affordable
In the
settlement agreement, I'm sorry.
I apologize. You have to
Not sure
go
what
back
that
in
is.
time. Sorry. In 2015, there was actually, as Ken alluded to, there was actually no legislative action that created laws for the third round. It was done by Mount Laurel 4, which is a Supreme Court case that was decided in March of 2015, that thereafter led to municipalities being given obligations and basically establishing the start of the third round, as well as a retroactive look at from 1999 to 2015 of a need. So Sparta had a third round obligation of 377 that was established by that third round process.
Oh, okay. Well, that time period looks so different than anything that has happened over the last 2 years, 3 years, and certainly since 2016, the job prospects and income prospects for people graduating college or graduating high school and going out into working as a mechanic, good solid jobs. The outlook is grim in many ways. And so it prompted me to look at what was the actual cost of living in New Jersey, not just here. And for one person, you would have to earn, and this is coming from livingwage.mit.edu, in 2025, you would have to earn as a one-person single adult before taxes $56,884. And that number meets the income limit for moderate housing, but it exceeds the limits for low-income housing. And I have talked to a lot of my older neighbors, and they've basically said that their kids go off to college or they graduate high school, and they cannot live in Sparta. They cannot live in Sussex County because it's just too expensive and they can't find, an apartment to rent. So I just kind of want to, I mean, I understand that we have to adopt this, and I just, I want to put it out there that this one-size-fits-all approach, hopefully when we actually get some actual applications in front of us, is there, like, how much wiggle room is there? Because I read the document, I read the ordinance, and it doesn't really sound like there is very much.
So in the lower, these are the minimum requirements, right? So if a developer could do more very low income units, which oftentimes they won't, that could be something that is discussed or asked, right? To do more very low income, or to do more low income versus moderate income, or whatever. And I think, that's up for discussion, but there are minimums that have to be met so that they don't get lost, right? Because those very low, these are all units that are basically subsidized by being an inclusionary, or if it's 100% affordable otherwise. And those income levels matter because the rents are related, or the cost of the house, if it's for sale, are all related to those income categories, and it's on a sliding scale. So a very low income, one bedroom, let's say, is $600 a month, but for a low income unit, it becomes, let's say, $1,000 a month, and then a moderate income unit, one bedroom, is $1,500 a month. So it gets closer and closer to what a market rate rent would be for that project. But that scale matters for all of those groups that, have those income needs. So I think it is tough that it is regionalized as well as regulated the way it is. But it does provide at least some consistency across the board for how it can be applied, and how you can income qualify the applicants for the units.
Board, just so it's clear, tonight, we're just looking at consistency on the rules and regulations. The density issue would be another time, just to really clarify for the public. Let's say the obligation in Sparta is 300, 400 units, whatever the number is. If we do not have a plan and a developer comes in and we have this obligation, a developer gets higher densities. So again, if the plan says you can have 100 units at this location, if we don't have a plan, or you don't have a plan, a developer could come in and say 100 is not enough, but I'll put 300, I need additional stories, and whether or not they get it or not, that's not for tonight. But the important part is that we have a plan, we have immunity, and we prevent developer suit. And tonight you have, for consistency of ordinance 26-03, Sparta fourth round amendment, fair housing plan for review, and your planner has given you the overview. And again, we're not talking about densities tonight, and that is what is before you.
Catherine, I think it's important to, we talk about immunity, but what really we're talking about is, we're talking about retaining control, right? It's immunity from builder's remedy. I think that's the important point here. So we want to have immunity from builder's remedy, so we retain local control.
Correct.
All right, thank you.
Any more questions from the dais? That having been said, I would like to open this to the public. Again, given the volume of people in the room, please limit yourselves to be as concise as possible. If you have a question, let's get it out there, get it answered. If you have a comment, please be brief.
And gang, I don't want to cut anybody off by saying that's not tonight, the density issue, but if you can have a density issue, nothing wrong with saying it on the record, and that's really before the mayor and council. Thank you.
Just your name and
Hi, it's Stephen Giles, and
Just
15
when you
Oakwood
live, you don't
Drive.
have to give your address, Stephen, just if you live in Sparta.
I live in Sparta.
Thank you.
I live in Lake Mohawk. I have three very quick questions. I would like to know when this is going before the council for final reading, because in the ordinance it says the 24th of March, but my understanding is that date may not be correct, and it might be next week. But obviously there's no agenda out there at the moment. So could if you know, can I have a confirmation of when that's going forward?
I believe it's supposed to be March 10th,
10th.
next Tuesday, yes.
Okay. I see Mike nodding as well, so that sounds okay. Perfect. This is a clarification of what I think I heard. I know we submitted the HEFSP back in June, and obviously there's the dispute resolution going in. That's ongoing. I think you said there's nothing that's coming out of that resolution program that is part of this ordinance tonight. Is that correct?
I believe that's correct.
Okay. And final question, when the dispute resolution program is completed and we start getting the readout from that, is the outcome from that an update to the plan that was submitted in June, a formal update?
Correct. So the outcome of that will be required to be put into an amended housing and fair share plan, which will have to be duly noticed as a master plan element and will have to be before this board for public hearing and adoption.
Great, thank you very much.
You're welcome.
Hello, Jim McMichael, Sparta. Just a question on, can you give us some examples, if there are any, of how you can lose this immunity? Because there's been a lot of talk about the immunity.
In the fourth round, I don't know if any municipalities, because the deadline is still March 15th, have lost immunity. But I do know that in the challenge period, which ran from July 1st to August 31st, there was challenges that questioned immunity. One municipality that I represented had its immunity challenged by Fair Share Housing Center on the grounds that it was not acting in good faith in the way it adopted its housing element, that it didn't provide, the opportunities to create affordable housing and therefore was exclusionary. So those are some of the reasons that have been thrown out there. In the case of the third round, at least in Englewood Cliffs, they failed to reach a settlement agreement with Fair Share Housing Center, and there was developers involved in that third round process. It was a lot different, similar in some ways to the fourth round, but different. And because their unwillingness to settle multiple times, a judge ruled against their zoning powers and essentially ruled in favor of the developers to strip their immunity. And so you'll notice if you look up the recent program decision by Judge Allen that was issued yesterday for Sparta Township, with the extension of the deadline to April 30th, it also mentions that the township, they recommend the township keep its immunity as long as it continues to negotiate in good faith. And as long as the township adopts all of the necessary documentation set forth in that order by April 30th. Otherwise, it could lose the compliance or the opportunity for compliance certification and also could risk immunity. And that's all outlined in that document.
So it is possible, if this gets adopted and we commit to a plan, it is possible to lose this immunity that we're talking about if it's deemed that we're not acting in good faith.
Now, let me clarify. Let's say our obligation is 300 to make it easy. And Catherine puts together a plan, the mayor and council has the plan, and that's adopted by the court. That is the process now. You have immunity. If, for example, one of the objectors in that particular property, you say that we only want 100 units there, but that property owner says, I should have 200 units. So they challenge, the municipality says, look, you don't have the sewer, you don't have the other issues necessary, and the density is too much for the community. The court can make a determination. Even if because if our obligation is 300 and our plan is only showing, let's say, 100 or 200 units, we are short on our obligation, but we are doing the best we can with the plan. And if the plan is accepted, that's why every 10 years you look at it again. So the only, in my professional opinion and experience, has been that you will only use immunity if you do not act in good faith and you do not have a fair and reasonable plan. If a developer says, I can give you, Sparta, compliance with your requirement as set forth by the court and by the formulas of the state of New Jersey, you have to be reasonable with that. So it's happening very quick. The good news is that most municipalities do get immunity, most land use adjudicators are reasonable, and most developers, to be candid, want to be able to develop, so they want to have a number that the municipality agrees with, and they can come before the planning board as a permitted use versus the Board of Adjustment, which is a non-permitted use, and you need a majority vote. So I hope that's been helpful.
Yeah, that is. So if we were to commit to whatever the number is, 100 units, 200 units, and we only deliver 100, like if we deliver 50%, would that be, from your perspective, not in good faith?
In my opinion, that's why Catherine's so important as a licensed professional planner. You have highlands. You can't build there. So there's-
Yeah, and I'll
yeah, go ahead.
just kind of jump in. This process, the fourth round process that was established was different in that there was what I called a challenge period. And so that kind of dispute process, the challengers, developers that wanted to get involved had their chance. They had till August 31st. They issued it. That's what the past 4 months was with this program, was most municipalities tried to reach a settlement. Sparta tried to reach a settlement. And there are still things that are in dispute. But if you read that decision, there is now a laundry list of things that the township has to achieve by April 30th. So it's more concrete. It's more firm about what has to be done. It's less about the township developing those units right now. It's about having a plan that zones for and shows what was agreed to as what happened through this program. So it's a very, that decision pretty much gives a very direct list of what the township has to accomplish in order to retain its immunity and then basically get it for the next 10 years.
So to answer your question, the housing element and fair share plan that she's going to present in the future will address how the obligation is going to be addressed, how the numbers are going to be met, and how the number will be adjusted. So the next meeting will have probably answer all of your questions regarding that.
Wow. Yeah, thank you, Lindsay.
Thank you, everybody.
And gang, we're very fortunate. We have 2 excellent planners with Sparta. We have one working on fair housing and one working on the master plan, and they work well together. We have an outstanding municipal engineer also who assists on those issues of practicality, that if there's no sewer, if there's no water, if there's no, so those are all part of your team here in Sparta. Thank you.
Hi, John and Cantalupo. I've lived in Sparta for 30 years. My family's been here for 56 years, specifically in Lake Mohawk. I know some of you, you're our neighbors, and I just wanted to thank all of you for serving our town. Probably not something you hear very often. Little nervous, I never addressed the board, but my question is sort of basic, and I know it's not exactly what you're here for tonight, but I think it's going to be a legitimate question, and that is that the whole theory of affordable housing has to do with incentive zoning. Basically, the theory that that developers are allowed to exceed certain zoning restrictions, correct, in exchange for providing amenities or features. And that amenity or feature in this particular case is the affordable housing. So my question is kind of twofold. Who exactly decide, and it's going to sound very simple, but I think it requires an answer. Who exactly decides exactly how much that zoning is exceeded by? Who actually makes that decision? And when are you going to make that decision? That's my question.
Catherine?
I will do my best to answer it as best as I can without talking too much about the specifics, because that will be something coming again with an amended housing element. As I just mentioned, the amended Fair Housing Act created what's called an Affordable Housing Dispute Resolution Program. I'm just going to call it the program, which basically has handled everything that Sparta has submitted to it since last January, including the numbers, obligation, all that stuff. And when it came even to the fourth round obligation, that program basically adjudicated if the township was correct in its assertion of what the number was versus the state's number, right? So that team had, or that program had a program judge who's a retired judge, and a special adjudicator who's a professional planner, similar to myself and Lindsay, who worked, through the state. And they made decisions. After the township adopted its plan before the June 30th deadline, from July 1st to August 31st, anybody
I mean, anybody could appeal the township's plan on the grounds that it didn't meet the requirements of the amended Fair Housing Act. Sparta received four such challenges to its plan. Fair Share Housing Center, 5 West Shore Trail, Jersey Investors Growth LLC, and DDG OPS LLC.
Those are all
Some
developers.
3 of them are developers. 1 is an advocacy group called Fair Share Housing Center. So that was the process for which developers made an ask essentially to the program, said, I'm not in the plan, or I'm in the plan and they didn't give me enough density. This is what I need. And essentially began a negotiating process from whenever that program set up basically court settlement, case settlement conferences. They called them settlement hearings because the court or the program was looking to settle cases. So their intention, and you can ask any of the program judges, was to settle, meaning they wanted to negotiate. So it was a negotiation. So if the township says, we want 0 units and we think this is why, it's got wetlands, it's got this, you can't do this, you can't do that, the program could respond and say, make a little room, do this, do that. So there was a planner and a judge who basically were adjudicating 300, 400 of these around the state, setting up these conferences and, working at warp speed to settle cases. Some towns had 1 challenger, some had 17 challengers, some had something in between. Sparta had something in between. And so I will not say, or I'll give you my opinion, that the process was not very kind to municipalities. If the intention is to settle, then it's not very kind, because you're not looking for just nothing. Someone's going to get something when you're negotiating. You're probably going to meet in the middle. And that essentially was the program's decision. So the program decision in order, if a township couldn't come to the table and say we're going to settle, most of the program decisions you'll see where that didn't happen either said we're taking it to court to figure we're getting a little more time, kind of like Sparta's decision says that. Or if you did settle, good for you, get everything done by March 15th and you'll get your immunity, you'll be on your way. So it was a push and shove process. But essentially, it was adjudicated in a quasi court through this program with a judge present, and that's how a lot of decisions were made.
But where does the planning board come in on exceeding of zoning and the town council?
So let me clarify. The program dictates what zones the town has to implement in order to make those sites viable. So if a developer X comes in and says, I want 100 units on my property, through the program they negotiated 50 and the zoning right now doesn't permit that, the township then, as a program requirement, in that order would say, zone developer X's site for 50 whatever units by March 15th.
Okay, but you're talking numbers of units, and I'm talking more height, use, other features of a specific site, but I'm not going to mention it because we're not here for that tonight.
And in most cases, that played into the settlement conversations. And so in townships that were lucky that brought that up and said, we want to restrict it to this high, to these setbacks, to this, those get included and can be included and can still be part of a zoning ordinance. So you're going to see, if you look around the state at town council agendas right now, you're going to see almost every town has on their agenda a zoning ordinance for an affordable housing site, and it's going to be a typical zoning ordinance that's going to establish bulk standards, density allowances, landscaping requirements, building height, affordable housing requirements, et cetera. So that zoning ordinance will not just capture the amount of units, it will capture the bulk standards that regulate it as well.
So essentially, it's the town council through an ordinance that establishes what the density of a specific site is.
The program,
not the planning.
The town council is the legislative body that adopts laws, and so the town council is the one that adopts ordinances.
But just so it's clear, the state has determined the number of units that is required in Sparta.
Right.
Sparta now has to say, practicality, what's feasible for that number. And the objectors could say, we can do better than that. And that's what that's where we are now. So, and that you got a good team, so.
Okay, good. Thanks. Appreciate it.
You're welcome.
David Fortunato, Sparta, New Jersey. I want to make sure I understood correctly that the ordinance 2603 was written in response to the program decision and the order from the court yesterday to bring Sparta in compliance with what those two documents had set forth. Is that right?
It largely follows the February 5th program recommendation from about a month ago. And then that program order that just came out yesterday, I had a chance to look at it, and that follows very much what it didn't go in opposition of what that the original recommendation included.
Okay, so the recommendation dealt specifically with two properties, right? Well, two properties that Sparta had negotiated a settlement with, and a third property that was still outstanding.
And those properties have not yet been introduced with zoning at the township council level. The only portion that has been addressed is the the more general affordable housing ordinance, which is a requirement eventually by April 30th now, as well as the repeal of the TC overlay, which has been permitted by that order, which is why I brought it up.
So the owner of one of the properties pled guilty under a federal indictment yesterday. So it's likely that that property will be seized by the government and no longer part of the consideration. Can we now go back and rewrite 2603 to revise any provisions that were specifically directed to that property?
2603 is not specific to that site. It is no way zones that site. It does not provide any zoning rights to that site. 2603 is a general regulatory ordinance that governs all affordable housing requirements in the township. That order has items that have yet to be accomplished by the township council, including that property, which, thank you for the news of that. And I'm sure it is something that we will bring up to Judge Allen as we go into the
And
court.
just to clarify, 2603 is, in a way, DCA had a template that they released that they recommended that every municipality adopt. That ordinance that is being heard today and we're speaking about right now is an iteration of what DCA had submitted. So the DCA.
And what is DCA?
Oh, it's the Department of Community Affairs. So it's a state, it's a state level organization. So when you look at this ordinance for affordable housing ordinance, you can look at Jefferson's affordable housing ordinance. You can look over at, I'm in Norwood. You can look over there. You can see that. And the ordinance is going to be almost identical in most of these municipalities, except for in certain places. It's a pretty general ordinance. The standards that are put in there are the standards that are across the state. So nothing in there is out of the ordinary. It's just what is being recommended to be adopted to reach compliance by the state.
Oh, thank you. One final comment. It appears that the proposed 2603 differs from the current version in a significant respect, that the current version allows for the incentive zoning for properties that are 2 acres or more. The subject property that I was talking about is a half an acre. And the proposed version, the proposed ordinance 2603 doesn't have that acreage limitation in it. So it seems to me that it was rewritten to allow for the 5 West Shore property to fall under 2603 and get the incentive zoning.
Let me clarify, because Ms. Furman had asked the same question. The incentive zoning ordinance, which you just referred to, that's under 18-8.5 I or L, I believe.
L1B.
Yeah, that section is being repealed in its entirety,
Right,
meaning the
got that.
incentives no longer apply not only to properties that are 2 acres, but no properties at all in those zones that are designated. It's being repealed in its entirety. It's not going to exist if this is adopted. I believe, and you can correct me if I'm wrong, 2603 includes a provision under proposed 18-8.5, number 4, the municipality-wide mandatory set-aside ordinance. This requires, it's not a provision that gives anyone zoning rights, that gives you the right to a density variance, redevelopment plan, rezoning. It simply says that if you do benefit from those things, that you have to require affordable housing. And the reason being is that you can choose not to. And you'll see in some cases where towns have fulfilled their full obligation or, received their certification previously, may have affordable housing developments that have an affordable set aside, that have a mix of market and affordable, but then thereafter they receive certification or whatever it was in the past from COA, that they decided to build full market rate developments and not require an affordable set aside, or didn't have an ordinance that imposed that requirement. This is not giving any zoning rights to any property. It is not allowing any property. It's just saying that if you do come before the zoning board or you seek a redevelopment plan from the council, you have to do affordable housing in your development. It is a requirement that hopefully will benefit the township in that any additional projects beyond what's in the housing element fair share plan would be required then to have affordable housing in them, and the township would get additional units towards any future rounds or obligations.
Thank you very much.
You're welcome.
Anyone else from the public? Okay, seeing none. Ken, would you mind crafting a motion?
Sure. We have before us ordinance number 26-03, the Sparta fourth round amended fair housing plan, which we have reviewed, and we have a written report from Catherine dated March 2nd, 2006, as to its consistency. It is also my professional opinion that housing in the state of New Jersey in and of itself is a positive aspect by way of the constitutional right and consistency with the existing master plan and the future master plan. So if the board, someone would move the finding that ordinance 26-03 as presented is consistent with the Sparta master plan, and that will be sent to the mayor and council in their consideration at, I believe, the March 10th hearing at second reading, in which public comment will be permitted.
I have a motion and a second.
I'll make the motion.
I'll second.
Roll call vote, please, Rach.
Christine Quinn,
Yes.
Deputy Mayor Mike Sylvester,
Yes.
Ron Day,
Yes.
Christine Dunbar,
Yes.
Joan Furman,
Yes.
Ernie Ragsdale,
Yes.
Brian Zimmerman,
Yes.
Birgit Bogler,
Yes.
Vice Chairwoman Jeanette Burt,
Yes.
Chairwoman Celeste Luciano.
Yes. Okay. Thank you very much.
All right.
That was a heavy lift.
Wait till town
I
council.
love, I just need to say something before everybody leaves, because I know that's what's going to end up happening. I love the fact that this room is full. I love the fact that people are present. I love the fact that people are paying attention. Please continue to do so. We are working on the master plan. Your voices should be heard, and your presence is truly appreciated. I really, I can't say enough about how much I appreciate the people in this room and anybody who's potentially joining us online. Thank you so very much.
Thank you.
Okay, Chair, it may be appropriate now to go into closed session. We're going to be talking about the pending litigation status, and then the room would have to be cleared anyway.
I move that we move into executive session.
Yes, can I have a motion and a second for executive at this
I'll
stage?
make a motion.
I'll second it.
And just for the public, when we go into closed session, we will not be coming back out for a determination. I am only advising them. Thank you.
And all in favor
Aye.
About the rest of the agenda.
or opposed? Okay. There will be public comment, so that's,
Well, why can't we do that before they,
that was my, I was a little confused because I was
That's
looking to
fine.
move forward.
I was trying to
With the
clear the
agenda.
room.
Somebody
I was
leave.
trying to clear the room.
You don't have to leave.
So I've been trying to talk to her to figure out how, because we never got credit.
Right, I had thought we had reserved the right to have that at the end.
Which is such a waste.
Go ahead.
I know.
Whatever they want to do.
Because most of
Whatever you
the
want.
instructions, I've been trying to talk.
I did, I just.
So we'll have executive later, guys.
If everybody wants to stay,
Anybody wants to stay?
We're
for
gonna move
open to the
executive
public for
session.
items not on the agenda, please feel free. I know nobody's going to stay.
Jim Castamore, Sparta. 2 weeks ago, you had a fellow here doing a traffic study thing. You had done any work before in Sussex County? No, Bergen County. What's your things? Well, Lyndhurst, American Dream Mall. Guy doesn't know the first thing about Sparta, and he tells you all about the traffic problems in Sparta. Let's see if I can get him straight. North Shore Trail, South Shore Trail, Pine Street, in case you don't know where Pine Street is, it's a little cut around. It used to be a dirt road. There's only one house on it. Pine Cone Lane and Stanhope Road. Woodport and Winona. What do you think about Route 15? There's not really any problems out there. Sparta Township needs, we need more walkways, sidewalks, and we need more trails. The guy works down Lyndhurst. Lyndhurst is less than 5 square miles. Yeah, that works down there. Sparta Township's just shy of 39 square miles. I think it's 38.75 if my memory corrects me. And I don't think anybody's going to walk from the Edison to the Stop and Shop on a sidewalk. It was the most poor traffic study I've ever seen. The man tells you that you should put in roundabouts or rotaries or circles. Ernie, where do you think we should put one? Pools Corner? How about Bedell's Corner? How about Longnecker Corner? I mean, this is, who hired this guy? Is he a part of the family and friends group or what? It was appalling. Poor. There's a police chief sitting right there. You could tell you it was a poor study. What do you think? Yeah, I can see the smile on your face already. I just want to tell you that. I mean, I've lived in this town all my life. For a man to come here and tell you, you need sidewalks and trails, you need roundabouts, really? I can see a roundabout at Longnecker's Corner. In case you don't know where that is, that's Woodport Road, Stanhope Road, and Winona Parkway. Yeah, I could see that there. That'll work great. What do you think? Tractor trailer coming down, kill everybody. The other thing, too, before I leave, the planning board needs to look at site plans more carefully. I'm going to give you an example. The new gas station over on Newton Sparta Road was put there a few years ago. The only way the gas tanker can get in there, he makes a left-hand turn on Perona Farms Road. He has to get all the way over in the shoulder of the opposite side of the road to get himself or back around to get in there. And if you go over and look at the curb, the entrance curb going in that way, it's all busted to heck. There's nothing left to it. I watched him the other day going in there. Half these guys don't know how to drive. Let's face the facts of life. You know, I've been driving all my life. I've been business. But when you start doing these things, and the other thing too is with all this lovely Belgian block you have in town, this winter was the shining example. Where do you put the snow? Push up to the curb, pretty soon you're 5 feet out. You couldn't get in the post office parking lot for 2 days because it was all snow. They had to go in and muck it out. They had to muck out the bowling alleys. But that's my thoughts. That traffic study was terrible. Waste of money. I mean, you got a former police chief sitting right there and he's got a smirk on his face. He knows that was a waste of money. Roundabouts in Sparta, sidewalks, yeah. Guys from Bergen County, what'd you expect? So that's my thoughts. Thank you. Have a nice evening, everybody. Thank you.
Thank you.
Thanks, Jim.
Hi, Jenny Derricks, Deputy Sparta. I just had a couple of questions. So the letter that's on the agenda, that's why I asked if you're going to do the rest of the agenda.
Yeah, we were anticipating doing the rest of the agenda, but.
Okay. And I'm sorry if I'm jumping the gun because you didn't get through it. Do you want me to wait?
Ask
All right.
a question.
So is this the first time that such a letter has been received by the planning board from DCR asking or extending time?
Yeah, I can answer that. There are letters, it's public record, if that DCR is taking the position, they're requesting extension of times. It was duly noted, and I put on the record in the past that we have dismissed the DCR application without prejudice, because it's, in my opinion, and the board had determined it was kind of silly for us to just keep it on the agenda when we're all awaiting the court determinations. So I believe that we are going into closed session, and I will give my advice as to moving forward. But it is not uncommon that Diamond Chip is asking for an extension, and this board has continually said, we dismissed your application without prejudice pending court opinion. So we're saying the same thing by way of outcome. We're all waiting for the court determination, but we have different interpretations.
So you're saying, because you said put this on the record before, I must have been asleep. I think I would have jumped up if I heard this. You're saying that that the planning board has dismissed without prejudice that DCR can come back. Does that mean they would be are they out of time? Out of the time of application rule?
You can Oprah my letters, it's public record. I made it on.
I'm not saying you didn't say it, I'm saying I missed it.
The court, Judge Minkowitz,
Right, told them to come back,
told them to come back.
and they haven't.
And they haven't. So as far as my professional opinion is that the trial court has directed them to do something which they have not done.
Okay.
Now, they have created their own rule by saying that they have the right to ask for a continuance. I'm not sure where they get that right. And the sad part with law is there is some gray area. They call it an extension. We're not saying that they can't come back before the board, but we are not recognizing that they have a pending application because they are not following the last court's determination. If the appellate court was to agree with DCR, Diamond Chip, and say that they have some type of vested rights and Judge Minkowitz was wrong, then they can come before the board saying they have prior rights. So I don't mean to be confusing. DCR is saying they have the right of an extension. I believe that is contrary to Judge Minkowitz. That's contrary to common sense. And we have written in response at least 3 times that I'm saying, thank you for your letter, but the board has determined that your matter is dismissed without prejudice because they could come before the board right now if they wanted.
Right. But they would have to come meeting the current.
Correct, Judge Minkowitz's opinion, yes.
Just to follow up on that, though, we did do all of that, and it has not been on the agenda. What caused it to be on today's
That
agenda?
was my next question.
You know something, I'll take a little bit of fault on that. I'm the board attorney since March. It's been 1 year, so thank you, everybody.
Happy anniversary.
And I'm merely given the litigation status. I had said to the chair, it's more than likely this discussion should be in closed session, and therefore, I wanted to give the board my professional opinion in closed session as to the pending litigation, where we are.
But the extension of time letter that we get every single month never makes it to the agenda. But it's on here now, like, I'm not sure what triggered it. Is this going to be on next month and the month after and the month after now?
No, I requested the chair. I personally felt it was proper for me as your attorney to let you know the status of the pending litigation, so there's no surprise, and there's, again, I'm doing my job. That's what I feel.
Thank you. I did have a couple of other questions real quick. At the 2 meetings prior, you had stated that under your authority as your town, representing the township in the DCR2 appeal, that you and Mr. Sylvester and Mr. Zepp represented the township in a discussion, I think you characterized it, with Diamond Chip. In light of the federal judge putting a hold on that case with mandated mediation, is it going to be the same team, or are there going to be different people representing Sparta?
That is kind of a tricky question by way of, we have counsel in the federal matter. I am handling the state appellate matter. The mayor and council will determine who will handle the federal mediation. But as far as, this is all good. The property within a community has utility. So whether that utility is a warehouse, is a community center, is a something else, is something that should be able to be reasonably worked out. Having a mediator look at it and make recommendations is very positive. If there's an opportunity for Diamond Chip, and I've said this many times, we're going through the master plan. If they were reasonable and had a reasonable plan and would like to bring that to our attention, now is the opportunity. So any litigation matter in the history of law has always settled one way or the other. So whether it settles through settlement or court determination, I would hope that DCR and the municipality are able to settle it either through the federal mediation or the good faith efforts of this board, but the ball is in their court.
Thank you.
Thank you.
Adrian Bierman, Sparta. I would like to go back to Ordinance 2602. We had, the chair gave us an opportunity to comment before, but I couldn't formulate my question quickly enough. When I look at the information about Roxbury and how they ended up with an ICE facility, it was an existing warehouse that was sold by the owner to ICE and is being used for a different purpose than to which it was approved whenever it was built in the past. Now, Sparta does not have any such buildings at the present time, so we cannot sell an existing mega warehouse to ICE to serve as a detention center. They were able to do it in Roxbury under the supremacy clause. If we had such a building in Sparta, they might do it in Sparta under the same supremacy clause. So my question is there any mechanism in the master plan, current or future, are there any ordinances that would prevent a developer such as Diamond Chip from obtaining an approval for a warehouse, turn around, sell it to a different developer, maybe one affiliated with ICE or specializing in the kind of structures they need, and be approved under one set of circumstances, sell the permit, sell the approval to a different developer who then goes arm in arm with ICE under the supremacy clause, and that's how we end up with, say, a detention center. It is hypothetical, but I'm thinking of Fluss Holdings, which got an approval for the high-rise apartment building and then sold the approval to a different developer who is now presumably building it. Is there anything that we have in our township that would stop such a mechanism, bait and switch, if you will, from happening?
Yeah, the nice thing about the master plan is we're giving the portrait of your community. Now, the Fluss application was for residential and was sold and continues to be residential. So that's kind of,
Sure.
So here, if a warehouse is approved and like in Roxbury, could the federal government just come in, and Roxbury is saying no, and the federal government is saying yes, and we'll see how that pans out. But I think the ordinance here, by way of the community of Sparta, is saying to the world, we don't believe this use works here for safety, for traffic, for a number of reasons. So you have put out your voice. Whether or not someone else wants to challenge it in the future, you can't prevent that, but you're sending a loud message that that land use you don't believe is permitted here.
So So ordinance
2602.
2602 is aspirational, essentially.
It's any ordinance that you put forth, let's say you own a piece of property and it says that you cannot put a bar in that zone. But you want to put a family community bar that you think would work in that area. You're going to limit the hours to a certain time. It's not permitted by zone. You go before the Board of Adjustment and you seek a use variance. So here, we are saying that it is not permitted in any zone, but could someone come in and go before the Board of Adjustment and seek a use variance? They could. Could the federal government come in and say, we have the supremacy clause and we don't have to get your approval, and you have a Roxbury situation? That could happen also. But if you are a legislator for the federal government or a executive for the federal government and you see Sparta has given a message, you may hopefully respect that message, that land use message.
Sure, and Roxbury shows that they don't listen.
But I don't think let's see how
Because-
I get it, yes.
Yeah, yeah.
yes.
So then I do have a question about the apartment building, maybe Mr. Simmons knows. Is it being developed, is it being built, and is it being built according to all the changes that we requested at the approval hearings last year?
That's FLUS, you're saying? the FL?
Yeah, the FLUS building.
Yes, I can speak to that because I've seen that they had a conditional approval, and they are obligated to provide certain documentation, and if they do provide that documentation, they can get an approval. It's conditional use, so they're checking it off. So at this time, we're awaiting their compliance, but if they do what they said they were supposed to do, they will be able to build the project.
And will it be built according to all the design requirements that we established at the planning board about a year ago?
If it was in the resolution and within the review, whatever was approved. David, can you speak any more to that?
Yes, where they are right now, we had received requests from the planning department in the town regarding a zoning permit, but they weren't able to issue the zoning permit at this time because they're still, as Mr. Porro said, working on complying with the resolution compliance with all the conditions. For example, to the best of my knowledge, at this point, they still have to, for example, obtain DOT approval for the access tie-in onto Sparta Avenue, which is Route 181, which is a state highway. They have to tie their storm drainage in, they have to tie their sewer in, their water, et cetera, et cetera. So there are conditions, and that's just one of them, for example, that they have to submit to our office so we can review it and then write a letter to the planning department and indicate that at that time, based on all the additional and revised information submitted, that they could go ahead with the project.
Okay, so nothing concrete yet, but we're still in the planning, in the approval phase. Okay, thank you.
And if they did have deviations, they would come back before the board seeking an amendment. And new notice would be given to property owners within 200 feet and in the paper.
All right. Thank you. Thank you.
Thank you.
Okay. I'm going to assume at this point we've kind of gone through correspondence. Can we move to updates quickly before we move into executive? This way we can end that portion of the meeting? Okay, so we will move forward to updates. Deputy Mayor, Town Council?
The Class 2 position, as mentioned earlier, should be on the upcoming agenda, and the position should be filled. That's the only update I'm going to provide right now. As you know, I've carried the updates back and forth. There's no other further updates. Unless I'm missing something, Ken? I think we're good, right?
We will move forward to the Environmental Commission.
Full disclosure, I was not there, but I did listen to the meeting, so I just wanted to let you know that we're still waiting to hear back about our Sustainable New Jersey grant. That is for, we're asking for $20,000 towards the environmental inventory, resource inventory, which would complement and be a part of the appendix of the master plan. So we still have our fingers crossed on that. And on a lighter note, we're applying for another grant from ANJEC, and that is for $1,500, and this is for a program that would educate the public as to the value of bats, and then we would have money to install bat houses in specific areas in our Glen and throughout Sparta upon their advisement. So, and then, of course, we're still having our Earth Day on the 25th. Out here. If it rains, it's inside. It's inside. We get to move inside. That's pretty cool. Yeah, thank you.
Thank you. Okay, for subcommittees, minor site plan subcommittee did meet this evening. We do have a pending application. We did not have an applicant in front of us, so there was no resolution to that application. We are anticipating to invite that applicant to our meeting on the 18th so that we can bring that application to resolution. And for master plan subcommittee, our next meeting is on March 9th. And we intend to discuss the feedback regarding the circulation element presentation and discuss our expectations moving forward. And we're going to review an updated schedule for future presentations, which has been presented to the subcommittee for review. And that is the update on subcommittees.
Question? What has happened with the minor site plan subcommittee minutes that were going back still to October, November, December?
Unfortunately, I have not had an opportunity to get back to them yet, given the fact that we're shorthanded administratively. I had to kind of set certain parameters in place so that we could keep what we've got moving forward, but it is on my list of things to do. I do promise that it will be. I also know that you're not going to be at the next meeting, so I will make sure that there's going to be something there for you to review. I promise
I
that.
might be, or I could call in, I don't know, we'll see. Because if you get January through December correct, and that was almost correct, I mean, it was like almost there, then it's just a matter of clipping out October and November, just.
I understand completely. I just unfortunately, personally, have not had time to sit with it, so
But you shouldn't have to, you're not the board secretary.
Right, but the unfortunate circumstances right now, we're shorthanded administratively. So in order to be able to facilitate them, I said that this would be something that I would undertake, and I unfortunately dropped the ball on this one.
Not blaming you.
Oh, you should. It's fine.
Just ask them where they are.
So yes, I do, I will get it done. I do promise that. Okay, moving forward, we've gotten through our updates. We've gotten through our open to the public. Now we can move forward with executive session. May I have a motion and a second for executive? So Jeanette's made the motion. Can I have a second?
Yeah.
Can we take a 5-minute break in between?
Yeah.
Does anyone mind? if we take
3
a-
minutes?
I don't
Good.
mind at all. I can use.
You want to do the break before the, okay.
Thank you.
So we will be taking a 5-minute recess, and then we will be going into executive.
And gang, I do not need the planner
Okay, we are finally back and
not
we are
recording.
ready to have a motion and a second for executive session.
Make a motion for executive session.
Can I have a second? All right. All in favor? Aye. Any opposed? Okay, we will be moving into executive session. When we come out of executive session, we will be moving into adjournment. No further action will be taken.
Okay.
gave us, which I didn't really even read yet. It was on the Awesome Acres. What's the bottom line with that?
That was just upholding the zoning in Sparta, that you're Sparta.
Because it said
Adjourn, guys.
count one,
We're back on?
count two defendant,
back
but I
on.
didn't know what counts 1 and 2 were.
So we are back on.
Motion to adjourn.
So we're, yeah, we have to come back into open. So motion second, come back into open.
Motion to open.
Second. All in favor? Aye.
Aye.
Motion to adjourn.
Motion to adjourn.
Real quick, just for the record, the closed session minutes, when we went into closed session, I talked broadly about litigation rights, and then those that were involved in the DCR matter who were accused did leave the room, and I gave some additional legal advice as to that matter, and so that's just for the
In case that wasn't heard on the microphone, on the live stream, Ken Poro, excuse me, stated that after some basic brief information regarding DCR, those who were accused from DCR left the room for the remainder of the executive session. We returned upon closing of executive session so that we could adjourn.
Motion to
And-
adjourn.
All in favor?